USGS Science for a Changing World, ORDA Science Webinars. The Office of Restoration and Damage Assessment hosts a monthly series of science webinars intended to provide our NRDAR practitioners, as well as our co-trustees, the most up-to-date information related to NRDAR practices, as well as cutting-edge science topics related to the field. Typically hosted by Jo Ellen Hink, USGS National NRDAR Coordinator, these webinars are available as recordings after the fact and posted on ORDA's website. For more information or to suggest any future topics, please contact DOI NRDAR at ios.doi.gov. ORDA Science Webinar. To assess or not assess, that is the question. Jo Ellen Hink, Moderator.
For those of you that are new to Microsoft Teams, you want to look at these buttons here. Hopefully you can see my cursor, but you want to make sure that little camera button is off unless you want us all to see you, and then that microphone, mute that so we don't interrupt our presenter today, who is Amy Horner-Hanley with the DOI Office of the Solicitor. Without another reminder that this meeting is being recorded and will be posted on a public website in the near future. So just a couple things. We do have some upcoming webinars. You'll see those here. In October, we have oil impacts on bird migration, different physiological impacts that stem from some Deepwater Horizon work. And then in November, we have a 101 topic looking at developing a conceptual site model. And then moving on into the winter, we have innovative data visualization. So going beyond your box plots and your bar graphs. Let's look at some neat ways to visualize our data. And then restoration banking, which is going to be a panel, and that's being coordinated by Tim Hosel. If you have not gotten this email invitation directly for this webinar, you can contact Samantha Foster at the email listed or myself.
Contact Samantha Foster, Samantha_Foster at ios.doi.gov to be added to the webinar email distribution list. Have a topic idea? Please type into chat box or contact Jo Ellen Hink, JHINCK at usgs.gov.
And then I'm always looking for topic ideas. All right, so we had the pleasure of having Amy Horner-Hanley with us today. And if you were on the webinar a bit early, you know that this group likes to do quizzes and Kahoots. So I do have a quiz for you, one question about Amy that's going to serve as her fun fact for her bio. So you can drop this in the chat if you want to, of who graduated high school with Amy out of these famous or pseudo-famous people, or names at least that you may recognize.
Who graduated high school with Amy? A. Actor Brian Klugman. B. NYT's national baseball writer Tyler Kepner. C. Second Gentleman's Chief of Staff Courtney O'Donnell. D. Actor Bradley Cooper.
So with that, Amy Horner-Hanley is an attorney advisor in the Environmental Restoration Branch, Division of Parks and Wildlife in the Office of the Solicitor. She joined DOI in 2006, where she has primarily focused on advising clients on natural resource damage cases. Among other cases, since joining DOI, Amy has worked on the Tar Creek and Big River natural resource damage assessments, the Asarco, Tronox, and Peabody bankruptcy cases, as well as the Deepwater Horizon oil spill. She is the National Bankruptcy Coordinator for the Solicitor's Office on behalf of the Office of Restoration and Damage Assessment Program Office. Her practice also includes advising the National Park Service and the Fish and Wildlife Service on other environmental statutes. Amy detailed in the Water Enforcement Division of Office of Enforcement and Compliance Assurance, OECA, from August 2016 to January 2017. Prior to joining DOI, Amy was in private practice at a law firm in Washington, D.C., working on environmental cases. She holds a Master's of Environmental Management and a law degree from Duke University. And for this particular topic, I've worked with Amy now for several years, and being a scientist that helps coordinate science for NRDA cases. Sometimes when is there enough science? When do we need more? As scientists, we always want to go a little bit further and have things complete in a certain way, but NRDA is a little bit different, as most of you all probably know. So there's some different constraints on that. So I've been asking Amy, probably the last couple of years, if there was something that we could do on this topic, and I finally convinced her to say yes. So the fun fact, I don't know if anyone had any guesses for her, but actually she went to school and graduated with all of these folks. And while they may be stars, I gave Amy a double star for presenting today, and also just her willingness to share her experience and perspective. So thank you again, Amy. I'm going to quit sharing my screen, and I'll give you an okay once I see your screen, just to make sure everything is copacetic.
All right. Sounds good. I see a red box. Are you guys seeing it?
I see it. It's not in presentation mode yet.
All right, let's do that. All right, can people see that?
Looks good.
To assess or not assess, natural resource damage assessment and restoration, NRDAR, conundrums.
All right, so I'm going to go ahead and turn off my camera, but I just wanted to say hello to everyone who joined, and thanks for taking the time this afternoon. I have a couple of slides prepared, but feel free to put some comments or questions in the chat box. I can't quite see them when I'm in present mode, but I'll try and take a pause here and there to just make sure I haven't lost people, or if there's questions that I can kind of address along the way. So with that, I'm going to turn that off. All right. So as Joe was saying, and thanks for the nice introduction, Joe, you know, one of the questions that comes up in our NRDA cases all the time is, well, do you do the study or don't you? Or how exactly do you go all the way? Or can you do something that's sort of like a pilot study? And so this presentation is aimed at trying to at least give some considerations, some questions to ask yourself when you're presented with the proverbial fork or forks in the road in your NRDA cases. But first,
Comprehensive Environmental Response, Compensation and Liability Act, CERCLA, Purpose of Assessment Plan.
I'm a lawyer, so of course we're going to go first into the regs. So looking at the CERCLA NRDA regs here, that's 43 CFR Part 11. It actually talks specifically about this document called an assessment plan, and it explains that the purpose of this assessment plan is that the natural resource damage assessment is performed in a planned and systematic manner, and that the methodologies that are selected for injury determination, quantification, and damages determination can be conducted at a reasonable cost, right? It should be of sufficient detail so that the public can evaluate whether the approaches that the trustees are proposing to assess the damages is likely to be cost effective and meets the definition of reasonable cost. So for those of you who are more maybe scientific based, or NRDA is a little bit new to you, you probably already realize that this is a little bit different, because in determining what science to conduct in a case, in a NRDA case, you need to explicitly think about what is a reasonable cost.
CERCLA, Contents of an Assessment Plan. 43 CFR 11.31.
The CERCLA NRDA regulations are quite detailed in a lot of different ways. It goes into some detail about what should be in an assessment plan. The description of the natural resources, the geographical area that's involved. We often call that the assessment area, the trusteeship authority. It goes on to say for certain types of assessments that are the most frequently used in CERCLA, you need to go into details about sampling location, the survey design, the analyses to be performed, the numbers and types of samples to be collected. So pretty specific information. You need to talk about the coordination with remedial investigations and procedures for doing things like sharing data and split samples and things like that. So going over this for some folks that might be new for the NRDA folks, our trusteeship authority looks at resources or services that we as agencies either own, manage, control, or the resource or service somehow appertains to us. So that's sort of the basis of what we focus on when we are thinking about conducting a natural resource damage assessment. The timing of an assessment plan in CERCLA is earlier in the process, right? You've already done your preliminary assessment determination, screen and determination, your PAS, and you've issued your notice of intent to conduct a natural resource damage assessment in the CERCLA regulations. So the assessment plan comes after that. It should be sort of shortly after that, but different cases have different timelines. But it's preliminary, right? The trustees haven't looked at all the data yet. You are still trying to identify what data you might need to figure out what happened here as part of a release of a hazardous substance. And I think that that's, timing-wise, a really important thing to keep in mind, because you aren't supposed to know all the answers yet, and that's okay. So sometimes, and we'll talk about some examples later, you might not exactly know for certain the geographical area that was affected, but you have enough information where you can define a general boundary of where you're looking. You guys, I've worked with some scientists that were sort of frozen on an assessment plan, because on the one hand, it asks for some very generic potential information here. What are your natural resources that are involved? But at the same time, it was asking for some very specific information, like sampling locations, numbers of samples. And again, you're more preliminary in your case, and maybe you don't know all of that yet. You haven't quite figured out each and every study that you need to conduct, and that's okay. So the practice tip for an assessment plan in the CERCLA context that I've seen a lot is you sort of have like a overarching assessment plan that gives this broad information that tells the public, hey, this is the area we're looking at. We're looking at these types of substances. We're looking at these types of resources. These are some of the methodologies that we're considering using. And then you can tier off that with sort of specific studies that you're going to do. Oh, you've decided to do a lab tax study. You need to do a fish survey. You need to do a bird study. And then each one of those study plans is also an assessment plan under CERCLA that goes out for the 30-day public review. But in that manner, you kind of comply with the contents of this assessment plan, but it's just that perhaps it's not all in one document. It's a series of documents that might be issued over a series of years while you're in the assessment phase of a CERCLA case. So for scientists that are writing proposals, this is probably a helpful list of things to keep in mind about the level of detail that might be needed in like a study proposal, for example.
Oil Protection Act, OPA, procedures for particular claims. 33 CFR 136.207 and 136.209. A trustee may present a claim for reasonable cost of assessing natural resources damages separately from a claim for the cost of developing and implementing plans for the restoration, rehabilitation, replacement, or acquisition of the equivalent of the natural resources damaged. Proof: trustee must submit the assessment plan, which forms the basis of the claim. Provide documented costs and cost estimates for the claim. Certify the accuracy and integrity of any claim submitted. Certify whether the assessment was conducted in accordance with applicable provisions of the OPA NRDA regulations.
So I'm going to switch over to the Oil Pollution Act, and what you see up on your screen is the procedure for presenting a claim to the NPFC. And I know that there's quite a few folks on from the NPFC here, so feel free to to put things in the comment box that you want folks to know about that process. But you can see that what they're looking for also, if the trustees are going to seek funding for an assessment study from the fund, is, which you can do separate from a claim for damages, is you need to submit an assessment plan that forms the basis of that claim. So you need to provide your documented costs, the cost estimates for your study. And what the MPFC also looks for is if you have a resource-specific study, like how does that fit into like the overall context of your strategy for the case? There's much more details about that claim process, but in this respect, you also, even in OPA, need to be able to write something down for your assessment plan. So some of you might be a little bit confused because I was just talking about the CERCLA NRDA regulations, that 43 CFR Part 11, and now I just flipped into the MPFC regulations and code there. But I didn't talk about the OPA NRDA regulations, right? NOAA's regulations at 15 CFR Part 990. And one of the reasons I did that is because the OPA NRDA regulations don't discuss an assessment plan. They discuss assessment and the requirements for what the trustees must determine. But in those sections of the NRDA regulations, it doesn't require a plan. The only plan that's required under the OPA NRDA regulations is a draft and final restoration plan. And so that's one of the important distinctions that I wanted.
OPA National Pollution Fund Center, NPFC. Claim requirements 33 CF are 136.105. Claimant, i.e. trustees, bears the burden of providing all evidence, information, and documentation deemed necessary by the NPFC to support the claim. Each claim must be in writing for a sum certain for compensation for each category of uncompensated damages resulting from the incident. A general description of the nature and extent of the impact of the incident. Evidence to support the claim. The reasonable costs incurred by the claimant in assessing the damages claimed. A copy of written communication and substance of verbal communications, if any, between the claimant and the RP, and a statement that the claim was presented to the RP the date presented, that it was denied or remains not settled, and, if known, the reason why.
Folks to highlight, wanted to highlight for folks here today is just that there is this distinction in process between CERCLA and OPA. And so in the CERCLA practice, we have this assessment plan, but it comes early in the process, and it's really meant to be a roadmap for the trustees and for the public about, hey, this is how we think we're going to run this assessment. These are the things we're going to look at. Maybe here are some ideas for studies we might need to do. Here's the general area that we're going to study. And so it gives people a notice about that, but it also gives them enough information to figure out, oh, that's something that's doable and can be done at a reasonable cost. So OPA doesn't have that same requirement under the NRDA regs. However, if you are going into, if you think you might need funding from MPFC, that is something that is will be needed from your case team. There's a little bit more about the MPFC claim requirements. I'm not going to go over them here, but I just wanted folks to have them here because I always think it's helpful to be reminded of what the trustees need to pull together in order to seek funds from MPFC.
What are reasonable costs? 43 CFR 11.14 EE.
I've talked a lot already about reasonable costs. And so I just threw up a couple of definitions up here to remind folks about what that looks like, right? If you're looking at a particular study or a particular analysis, you want to look to see if the anticipated increment of the extra benefits of that study is, or using a more costly methodology, are greater than the costs of that methodology. Reasonable costs also, always, your costs of your assessment should be less than your damages, right? So there's a couple of rules of thumb. I'm sure different agencies have different rules of thumb, but overall, reasonable costs are less than what you anticipate your damages are going to be. So this is another sort of practice tip for scientists who might be thinking about different study plans or the trustees have approached you and said, hey, you're an expert in XYZ. We'd like you to study the effects of benzene on, this resource. How would you do that? Can you put together a proposal for us? And it might be helpful to think about it in different phases or in different types of tasks that have associated costs with them so that the trustees can think about what costs would be reasonable for those types of studies. So we build this talk as a presentation about the science, right? Like whether you go forward with a science, with a study, do you need more data? How do you make those decisions? And I know that I've talked now for 15 minutes or so about regulations and process and cost. And so again, for folks that might be new to NRDA, that is part of why NRDA is different than some of the science that maybe you're used to doing, which is we follow regulations and we are in the process of preparing a legal case. And as part of that process, we carry the burden of proof, and there are certain things that we need to be able to provide evidence to support our claim. And so we come to science a little bit different. We come to science with specific questions that we would like to have answered. That sometimes works better than others because knowledge is always evolving. But I wanted to highlight again that this is NRDA, and so we need to balance a lot of different competing interests out there. And so that's one of the differences in the scientific process. So let's talk about some science considerations. How do you know what natural resources to focus your assessment on, right? A spill just happened, a release of hazardous substances has occurred, it's an NPL site and you're coming to it. How do you figure out what to study? And one question might be, well, study it all, right? But you can't do that because you have this requirement to do it at reasonable costs. And of course, you don't have all the time in the world, although sometimes maybe at NPL sites, it feels like that. So you kind of need to figure out a way to make decisions about how to select which resources to focus on. Some of it might be easy, right? It might be a resource management priority, like threatened and endangered species. It could be habitat, right, on like BLM property or MPS property. It could be a resource that's culturally important. Maybe there's certain types of plants that are culturally important, and so you're going to focus on what may have happened to plants as a result of a release. There's other considerations that you have out there, like it is better to rely on known information, published literature. It's easier, it's more accepted. And so you might want to say, there's published literature on the toxic thresholds of whatever the substance is on the resource that was injured out there or was potentially exposed to the spill. So you're going to want to kind of know what's known about the effects of the hazardous substances that were spilled and potentially the resources at the site that were exposed. Same thing for sampling. There's often different sampling methodologies, and so you want to select established methodologies, ones that are well accepted in the community. Some of these, like the state might have published, this is their standard vegetation survey methodology, and so that may make your decision easier, right? Okay, you're going to go with the published methodology for the state in which this spill happened. That's great. It might get more complicated, however, if the published methodology is 10 years old and there's new information about a different methodology that's supposedly better, more accurate in some way. And then the trustees need to make a decision about, oh, do you go with something that's established and published, or do you try something new? And that's a conversation that the scientists should really have and be able to defend whatever decision they make. Oh, we're going with the published one, even though it's older because it's known, or no, the results from this newer methodology are equally reliable, and so we're going to go with that. Another consideration you might have is laboratory tox testing. Are there established methodologies for that? Has it been done before? Can you just rely on data? How are you going to design your tox study to get at the answers to questions that you might have? Are there established proxy organisms, right? Maybe it's a teeny species and you can't really experiment on them, so can you do it somewhere else? Maybe that's an easier way to do your assessment. And the last one here is really important, and in a way it should have been the lead, right? Which is the goal of NRDA is restoration. And I think when we go through this entire discussion on assessment, I think it's important to bear in mind that the goal is to actually restore the resources and the services that were harmed. And so it's important to think about as early as which resources do we focus our science on, which resources do we assess. You want to focus on ones that can be restored. NRDA is not about, hey, we proved that there's injury, so there's injury out there, right? We have to go the step further, which is there's injury, and this is how we're going to compensate the public for that. So if you're thinking about looking at a resource, but the techniques aren't quite there yet to restore it, pause about that and maybe think of something else to do, because it's not very helpful. It's not a good story to tell that says, hey, this resource was injured, but I'm sorry, there's just nothing we can do at this time to bring it back. That's not really what our goal is for the NRDA process. I'm going to pause there. Are there any questions in the comment box? I can't see.
Not yet.
Okay. Defining the assessment area. We chatted a little bit about this earlier in the talk. The assessment plan in CERCLA world comes earlier in your assessment process, and so you don't know all of the answers there. I was working with a trustee council recently that was concerned that they didn't have certainty about the geographic boundary of the incident that occurred, and so they were reluctant to put out for public review and comment, hey, here's the boundary for our assessment area. And I think it's important to include that in your assessment plan, in part because that's what the regulations say that you should do, but it gives general notice to the public about where you're focusing on. And I just wanted to reassure folks that the assessment plan, even when it's final, it's preliminary, right? You haven't gathered all of your data. So as you're going through the assessment, you might stumble upon data that was like, oh, you know what? The impacts were broader than we thought, or the geographic area is broader than we thought. We hadn't realized that there was a, whatever, and it took the substances further downriver than we thought. That's okay, right? Because there's going to be other documents that come out publicly that from the trustee council that can correct that and say, hey, unbeknownst to us, here's this data, and so we expanded it. The same thing, and I think this happens more often, is if the injured area is ultimately smaller than what you've put in your assessment plan, that's okay. Just be able to justify it and support it and say, hey, we looked at the data and it's actually smaller. It's in this area where we were able to document evidence of injury there. So it wouldn't be NRDA without talking about our friend Daubert or Daubert. I don't think there's ever going to be agreement on how to pronounce that. So for folks that are not accustomed to working with lawyers, when we're looking at a legal case, we have to figure out like how to put this on in court. And there's certain rules and evidentiary standards that we have to meet. And one of these is called the Daubert standard. And so another one is also like trying to qualify your expert, right? And so you can have the other side try to disqualify your expert, just like the other side might try to disqualify a particular study that you did because the methodology is kooky in some way or shape or form. So in the back of your case attorney's head, when you are starting to go down the assessment pathway here, are these factors for reliable scientific evidence and expert testimony. So is the technique that you're talking about, has it been peer reviewed? Is it published? Is there a known or potential rate of error? There's a reliability assessment, or the methodology is generally accepted within the relevant scientific community. And then there's the fourth one, the testability of the technique. Sometimes that's referred to as falsifiability, or reproducibility. So when you guys are starting to talk about different methodologies or different studies, what the lawyers want to hear is it novel, or is it something that's like, oh yeah, everybody knows the TIVA test, and so you can use it. It's well established. If a technique or a methodology is novel, it doesn't necessarily disqualify it from consideration in a NRDA context, in a NRDA assessment. It just means that we know that there's more risk involved with pursuing it. And so that's just something that we need to take into account when we're trying to figure out, is that a reasonable cost, right? If you're using a novel technique that hasn't been tested, we need to ensure that that's a reasonable cost. We understand that, like, someone has to be first, and sometimes that can be the trustees, but it's worth some extra discussions about the pros and cons about doing that. A couple of examples in my head about that I've been thinking about Dilbert on is, for example, eDNA. I can't remember, Joe, when it was that we had that presentation at the ORDA conference, but maybe at some point in time that was a new methodology, and it was maybe too risky to include in your NRDA assessments. But there's been a lot of work done on eDNA analyses for at least some species, and so that's sort of come more, in my personal opinion, has come more mainstream, and it's not so novel anymore. It's something that we can use reliably in NRDA cases for answering specific questions. Maybe, and some folks have this in their cases, I know, mercury isotopic analysis, right? We're using it in our NRDA cases, but that's a fairly new science, but that doesn't mean that it wasn't reliable. So there's this understanding of the methodology and the study techniques that are being used is important for the legal case team to understand, so that we can appropriately evaluate the strength of our case going forward. I'm sure folks can think of a lot of other endpoints for their assessment studies. I just threw some up here. Feel free to type others into the chat box. Presence, absence, density. Normally, generally speaking, quantitative is going to be better than qualitative, unless you're maybe doing some type of pilot study or a survey just to get enough information to inform like the potential next phase of a quantitative study. You'll have to think about, whether those costs are reasonable to do it stepwise like that, but just knowing that something is there, as opposed to how many are there or not there, is not very helpful when it comes to trying to quantify your injury. Other types of studies out there might not be focused on injury per se. You might have studies that you need to do for exposure pathway. You're kind of looking at, hey, was the substance bioavailable, or like, did the substance get up on the floodplain, or is it in the prey items, or is it just in the, habitat? Trying to look at those types of questions. And so obviously that's not you don't necessarily need to have that be a quantitative study, because you're just trying to understand sort of the mechanisms of what happened in the NRDA case. Here, finally, for folks that were not familiar with the definition of injury, it's a measurable adverse change, either long or short term, in the chemical, physical quality or viability of a natural resource resulting from exposure to the oil or hazardous substance. We trustees tend to focus a lot on survival or lack thereof, a loss of reproduction, either as a result of directly of exposure to the oil or hazardous substance, or indirectly as potentially a delay in reproduction. Looking at lost biomass. There are other endpoints, right? Especially in some lab tox studies, they look at growth. Sometimes you can say, oh, there's anemia, maybe there's genetic mutations, maybe there are these other sublethal effects. And so they are injury. I think the harder part for the trustees to date, and I think that this is something that we're all working on in our various cases, is if it's injury, how do we quantify it? And then how do we restore it? So I think that that's a really interesting area for NRDA cases going forward. But right now, for the scientists who are here, who are thinking about different studies for NRDA cases, we are kind of focused on the death and destruction kind of mode, because it's easier for us to quantify and prove at this time. So let's talk about some pros of performing a scientific study or methodology, right? Like, hey, of course we want to go out and do this study because we could prove the case. Like, this could be it. We can absolutely show that this substance caused those fish to die, and like, this is great. You could also lessen uncertainty, right? Like, sometimes you're like, well, we're pretty sure that XYZ result happened, but it would be better to get some more data on that so that we can be more sure. And then as you go through cases, there's always data gaps. And so you might design a particular study to fill that data gap in order for us to be able to complete the story of the NRDA. These are really helpful when you start to think and grapple with these issues of like, do you go forward and assess the resource? Do you go forward with the study, or do you not? Like, do you have enough information? That fork in the road that we talked about earlier. So yeah, people think, let's go forward. More data is always better. You can prove the case. Let's go forward with it. Some cons of performing a scientific study, and I know some folks might be on the call thinking, why could there be cons? More data is always better. How could you think otherwise? And one of the reasons is that the data that you generate could be confounding, right? It might not be clarifying. It could actually be more confusing. And just remember that we're in NRDA world, where we have specific questions that we need answers to. Was XYZ resource harmed by this substance? Yes or no? If you generate data that's like, maybe, that's really hard for us to figure out whether to go forward with the claim or not. So it's great for the resource, don't get me wrong. Like, oh, you know what? It actually wasn't harmed. Fabulous. Like, the resource is in great shape, and our NRDA is now complete. So it's important to kind of think through, oh, what type of data might get generated from whatever the study proposal is that you're considering. We understand that you might not be able to perfectly predict what the outcome of a particular study is. You might have enough information to think, this is what we expect to happen. But if that doesn't happen, then what happens as part of your assessment case? So sometimes you want more information, you want more certainty, but you have enough information on which to base your claim. We talked a little bit earlier about novel scientific methods. Sometimes it's appropriate, sometimes it's not appropriate. The Dalbert standard, if it's a weak methodology or it's new, it might be perceived as undermining your credibility. Oh, the trustees had nothing to do, so they reached out and tried this unfounded process, and so it actually is a weaker statement about your case than perhaps you're really willing to make. And then, of course, with any kind of study that you're thinking about, there's a time delay to reach that resolution. Sometimes you think that you've completed your assessment, you're putting together your claim document, maybe you're even in settlement negotiations with the PRP, and they come up with something and you think, oh, we could design a study and get the answer to that, right? But it takes time to pull together the study, get the funding, get the data back. So that adds 2 years onto your case, onto your negotiation. And so you kind of have to think about, well, is the juice worth the squeeze in the particular context of your case? All right, so here's a little bit of audience participation. I don't know if there's any comments yet. I'm gonna guess no.
There was one from Lisa that noted when you were talking about your assessment area that you don't want to make it too big. Often the PRP will want a CNTS for the defined assessment area. So that was way earlier.
Yep, that's true. All right, so if folks could use the comment box to answer what they think the answer is. It's the game is to assess or not assess, right? Or to use this methodology that I'm going to put up on the screen. And so you can say yes, go forward, or like no, don't use this methodology in NRDA, or at least don't use it yet. So let's see how my animations work.
Chat responses for the following quiz questions are not visible or captured in the video.
So use of Cytochrome P450 in injury determination. What do folks think? So I see some people writing it. Yeah, you know, it goes to sublethal effects potentially, but yeah, so you know, it is helpful maybe to measure that to see if there was exposure, right? There was some type of response after exposure to a particular substance, but it might not be a good measure of actual injury for purposes of NRDA. How about use of turtle sniffing dogs to locate and count endangered sea turtle nests? So I think Response actually experimented with this technique, and so some people might be more up to date on it than others, right? So this is one of those, well, it was novel, and you'd kind of want to look into how effective it was, right? It has been done before, so it might be something that's useful for trying to quantify how many nests may have potentially been exposed. So this is one of those where you think about the Dolbear standard and cost benefits and kind of figure out like how strong is that methodology potentially. Right. A survey of oysters designed to generate statistically significant results that cost $32 million. Yeah, I mean, your responses are right on, right? Like, well, there's some missing information in this, like how big is your claim, right? $32 million for one study is a lot of money. And so you'd want to figure out, is that a reasonable cost, right? statistically significant results are really helpful in NRDA cases, right? That's sort of something that our goal is to get to statistically significant results. But we also have this mandate that we conduct our assessment at reasonable cost. So, excuse me. So this is one that you would want to talk a lot about in the specific context of your case to figure out, is the 32 million reasonable given the details of your case? All right, and then one more, but it's sort of already been answered. I think Jeremy Moore kind of answered this, which is, biomarkers can be helpful to show that there was exposure, but using it for quantification might be difficult. And so you would want it to look at sort of other endpoints, at least at this time, to be able to really quantify, how significant was that injury? How big was it? How long was it? And figuring out how to restore it. All right, so here are some tips for case managers working with scientists. And I don't mean to imply that some of the case managers aren't scientists. I'm using scientists here as, the folks that don't have NRDA lenses yet, and you're like, hey, you're an expert in this resource. Can you come please help the trustees study this resource for our NRDA? And they're like, great, can you spell NRDA for me? So it's really important to sort of explain the basics of NRDA, explaining that it's a legal process, that we have co-trustees, that we have specific questions that we need to have answered. That fits into this next tip here, which is the case manager should be able to express the need for the study, the questions that we have and how it fits into our claim. Because we do have specific questions. It's not just a general scientific exploration of, hey, what happens if? And I think it's important for all parties to have clarity on what the trustees are looking for. Case managers should engage the proper scientific experts. What do I mean by proper, right? We talked earlier about the need for the experts to be qualified for court, for example. So we're going to want to look at their credentials and make sure that we would be able to certify them as an expert in their field. And there's other more practical considerations too for NRDA cases, right? There's confidentiality considerations. So there might be a professor at a university that is the preeminent expert on whatever the resource is that you're interested in. However, if that university is a state university that has a very open Sunshine Law Act, you're going to need to think very hard about whether that's the right expert for your case, because so much of the work that we do initially is privilege, right? It's attorney-client privilege, it's work product privilege, it's generating data and interpretation for a potential legal case. And so maybe those two conditions don't match well with one another. A lot of our cases are going under litigation holds, and so I think most of you are familiar with what those are, but basically, the lawyers come out and say, please do not delete anything that has to do with this case. Voicemail, text message, data, email, any type of electronic or hard copy document until such time as we tell you that this can be lifted, and that might be 20 years from now. So it's important, right, that the expert kind of understands that and is in a position to be able to do something like that. Then, of course, some of our cases have time sensitivities, and so you just have to make sure that the scientist that you're working with has the capacity to deal with the ebb and flow of some of our NRDA cases. It's really important to be clear on the final product of what you want from the scientist. And Joe can pipe in here if I get this wrong, but USGS has a couple of different report options. But one thing to be aware of is that the internal report option that they have also means that it can't be cited. So that might have limited use for a particular NRDA case where we're looking for, data that can go out to the public and that we can potentially rely upon in court. But it might be a two-phase product, right, where you have a report and then you decide, oh yes, you know what, let's go forward and try and get this study published, right? You might not realize at first that you want it published, and so you might have to go back and renegotiate that. But I think it's really important to have those conversations about expectations. One question that comes up a lot in my cases is this an injury report, right? Injury arguably is a term of art for natural resource trustees. And so if you're working with a particular expert who might not be an expert in NRDA, and they've performed a study for you, then you might need to figure out if their results reach the conclusion of injury or if they are just stating the results. There was a toxic effect seen in the lab when we conducted this study, and then at a later time, the trustees can interpret that toxic effect to be an injury for purposes of NRDA. So in part, this goes to the level of comfort that the expert scientists might have with respect to reaching a conclusion of quote unquote injury. Some are very comfortable, some are not, but you kind of need to be clear about that as you go through. We should also be clear about just the level of effort and expectations for involvement in the case. A lot of times, case teams reach out to particular experts to run a study or a series of studies and maybe advise them on the interpretation of their results in how we develop our claim. That's a far cry from, hey, please come be a permanent member and advisor to the trustee council. That's not to say that some trustee councils don't hire scientists to do that, right? You can have science advisors sitting on trustee councils to help them. But again, you need to kind of be clear with the folks that you're working on about what the level of effort will be and what the expectations for their involvement in the case, and particularly with the trustee council, would be. On the other hand, here are some tips for scientists who are engaging on NRDA for their first time. There's materials out on the web, so you might want to educate yourself on the NRDA process. Hopefully the case manager will also provide you some background, but go ahead if you're thinking about getting involved in a NRDA case. You might want to do some background reading on that and be sure that you understand how your study fits into the case assessment. Make sure that the techniques or the methods that the trustees think that they want you to use are appropriate for what they're trying to measure. Be aware that whatever data and reports that are generated will be reviewed by the trustee council, not just the case manager, and that will include legal. So your timeline and iterations may be affected. I know that I've had lots of conversations with folks that say, oh, it's already been submitted for peer review. I'm like, well, that's fantastic, but it needs to come to the trustees before it can go out to the public. And that was a surprise and not necessarily a nice one, because sometimes it takes some time to go through trustee council review. So we try and avoid surprises. And so just want folks to know that typically when you are involved in a NRDA, it's at some point you will be engaged with the larger trustee council. When you're writing your report, be able to state your results in a clear and concise manner. So not all the case team members have a scientific background. This is a public process. And I know that this is a little bit different than what is more accepted scientific writing technique, right? So in NRDA world, my advice to scientists is always tell me what the results say. Tell me, when you look at these charts, this data, tell me what you think it says as it pertains to the question that we asked you. is there a toxic effect? Was there a reduction in biomass? If there's a particular chart or charts, a couple of them that sort of clearly lay out and support the conclusions that you reach of your study, please pull that into the main body of the text instead of leaving it in the supporting information. And again, this is my advice for my case teams, but when I'm reading through a study report, I don't want to be left hanging, being like, hey, so was the resource like harmed or not harmed? Or how big was the area that was harmed? Please don't tell me to go look at, table 27. Just incorporate that information in so that it's easier to be digested by folks like me, but other folks from the public that might be interested in how the study went and how it supports our case. Another hint to practice tip is just to be mindful of your area of expertise, right? So if you are in your area of expertise is a malacologist, or you're an avian specialist, you're a fish biologist, that's fantastic. And we've hired you because of that level of expertise. There are a lot of other things that NRDA case managers need to prove for our case. And so trying to figure out the line of how much of that to include in your report versus in some other trustee report is worthy of a few discussions. What am I talking about, right? So a lot of times what I see is a discussion of the PRP's liability in a report discussing, a muscle survey, for example. And so you have to go back to the credentials of the person that's writing the report and say, well, you're a malacologist, how comfortable are you saying that this company released hazardous substances that, polluted 18 miles of the river? That might not be a good fit for that level of expertise. Yes, you can cite to published reports, but the reason why we hired the malacologist is to tell us about the mussels. And so it's not necessary for that person necessarily to tell us to try and prove the liability of the party in addition to the results of their mussel survey. So yes, you're going to have in your reports, you're probably going to have something like this work was done as part of this natural resource damage assessment. You will probably have a pretty short description of whatever the incident was or the spill was, to try and tie it in and to give some context to the question that you're researching in that study. But otherwise, just be mindful of what you feel comfortable as the expert that we're hiring as a scientist, what you feel comfortable saying as far as areas outside of your expertise, but also with respect to your results, because you may have conversations with lawyers or with case managers who are trying to understand the results. And we might say something like, so what you're trying to say is XYZ, and you'll be like, no, that's not really what I'm trying to say. It's, ABC. And so don't be surprised if you have those kind of conversations, because I'm trying to understand what it is that the strengths and weaknesses, the limitations of the data that's there. And so part of the engagement with the NRDA trustee council, with the NRDA legal counsel, is trying to make sure that we both understand each other and that we are not putting words into your mouth, and that you're comfortable with what is being, how your work is being interpreted by us. So I know I'm getting short on time here, so let's see, a couple of final thoughts.
Study plan needs to be specific re-methodology to be used, sampling plan, and quality assurance plan. OPA practice tip.
MPFC can seek additional information on the need for a study if you go forward with an assessment plan to them. Please remember that some certain is just that. There's no more negotiating on an assessment plan after the presentment.
CERCLA practice tip. Tier off the more general assessment plan with resource-specific or other specific study plan.
The assessment plans need to go out for a 30-day public review and comment period. That's true for MPFC, that is true for CERCLA. And just remember the difference between OPA and CERCLA regs when it comes to the assessment plan. It is one of the more significant differences between the two regulatory regulations. In practice, it's not that different, but it is a distinction that the NRDA case team should be aware of. And that's it. So are there any questions?
Hey, Amy, great. That was a great presentation. Hi, everyone. This is Emily Joseph, Office of Restoration and Damage Assessment. Joe had to step out for another meeting, so I'm just going to go through the questions here. And then if there are any other questions from folks, be sure to put them into the chat, or you can raise your hand too. So, Amy, there are a couple comments and one question. So I'll just hit the first question first if you have time. Are there tools to evaluate and incorporate uncertainty in NRDA? For example, in eco-risk assessment, we use weight of evidence approach.
Yeah, so you can do a weight of evidence approach in NRDA cases. I'm struggling. So I think the trick there is that it goes to the strength of your claim. And so weight of the evidence is very helpful. And sometimes that's what you have, right? Because science is finicky. Sometimes you just can't quite study it the way that you need to get an answer, right? And so you kind of piece together the clues and say, as a result, this was injured and this is how much restoration we need for it. So yeah, you can use weight of evidence, but it does go to considerations about the strength of your case and litigation risk ultimately.
All right, great, thanks. And then we just have a couple of comments. I don't see any other questions yet. John Eisenhart mentioned that some of the issues that you mentioned can be partially remediated by statistical and science reviews of study plans. For example, how much statistical power is necessary.
That's a great tip.
And then John also wanted to remind folks about the upcoming webinar at the end of October on bird energetics. They're going to be talking about sublethal effects, which was mentioned earlier in your presentation. All right, I don't see other questions. Are there any other questions or comments for Amy? Last call. All right, well, great. Well, thanks, Amy. Appreciate your time today. Oh, wait, one just came in. In your experience, how often is restoration coming up front?
As far as actual restoration on the ground or trustee consideration of restoration techniques?
I'll let Ada, if you want to go off mute, and trustee consideration, she put it.
So I think that so for newer cases that are getting underway, I think that is a much more frequent discussion early on, which is what are your restoration goals? And so I think for some of the other cases that are a little bit older, like they're, hindsight's 2020, like, oh, we should have thought about that then. But I do think that the practice is trending more and more towards, oh, okay, so there was an incident, there was a spill, like, what are your resource priorities? What's under your trustee authority? But also, like, well, what are the restoration opportunities out there? But I do think that is that's been slowly shifting for any number of years now, in part because of ORDA's focus on restoration, at least for the DOI practice. And I do think that it's kind of being infiltrated into a lot of the cases at this time.
All right, there is another comment about DOJ, and your colleague Mark Barish has weighed in. Question about DOJ. Are they more strict concerning the science? Is that your experience?
So like I was saying, you know, and Mark, feel free to pop in here if you want. The lawyers are paying attention to these other things, these other federal rules of evidence, how to qualify experts, the Doe-Bear standard, and how to tell the story in court. And so in that respect, if there is a case that is likely to head to litigation, maybe over recalcitrant PRP, you know, different things, all of those additional burdens would need to be met. I think, so I'm not sure if I would describe it as more strict. It's just that there are these rules that would come in and apply. And so they want to make sure that the work that the trustees are doing is litigation ready. Mark, would you put it a different way?
I think I responded a little bit more flippantly, but to the exact same point, which is when it comes to litigation, we have very similar views. It, you know, depends. There's room for individuals to differ based on the specific set of facts in front of us or options available. But basically, we share the concern that it needs to be sufficiently strong to work in litigation under the litigation rules. To the extent there's a difference, I think it's more, I think what Ken was alluding to or suggesting is there's a difference in what value we can find in negotiation with data that may in fact not make the cut for litigation. And DOJ, as you just pointed out, is primarily focused on the litigation side. What is or isn't good enough for that purpose.
All right, thanks, Mark. We have another question. I've seen that sublethal parameters may not always be quantified, but do help to tell the story. Do you find this useful in a case?
It depends on the case, I guess. I think that the hard part for me with that question is the trustee's reliance on it, right? So if in fact the only evidence you have is one of these sublethal effects, but we weren't able to kind of show it in some other way, I'm not sure that that's very helpful. Because you're left with the sensation that, oh, something happened and we just couldn't figure out how to measure it. So I'm sort of half on the fence about that, right? Like if you're going to go and do a study that measures some of these sublethal effects, like don't do it unless you're going to follow it up with another study that gets to data that can be used for quantification. Mark or John Eisenhart, do you guys have different opinions?
No, completely agree. I think it's really can be valuable as a sort of second tier, either explanation or support for the why. So if you have a decrease in reproductive success that you're connecting, and then you can prove or establish a bunch of sublethal effects and have people explain this is why they believe the reproductive success is lower. The stuff is messing up a bunch of cascading sort of system issues, and these are all consistent with drains on various functions, and you're seeing it as a loss and a change in the reproductive success, which is what we're going to measure as their damages and try to restore. So it can help establish sort of the backstory behind causation.
Yeah, and like I said earlier, I think sublethal effects is one that trustees are grappling with on a lot of different cases, and I know that I'm looking forward to how that science evolves and how we can use it more effectively in our cases.
All right, great, thanks. I don't see any more comments, questions, so last call.
I have to go.
All right. Well, thanks everybody for joining us today. Thanks, Amy, again for the presentation. Really appreciate it. And everyone have a great day.
Thanks, everyone.
Thanks.